Hello, everyone, and welcome to our webinar on government sanctions regime and how all firms can stay compliant. You may already be familiar with how our webinars work, but just in case, we want this session to be as interactive as possible. And we have already had a good number of questions sent in advance, and we'll be picking those up. But you can also submit live questions by clicking on the question link just below this video. And you can choose to include your name with the questions, but you also have the option to submit those anonymously. We'll try our best to answer all your questions as we go through the webinar. And this stream will be available on CatchUp, and so will the slides to the links on the relevant web pages on our resource page for this event. And feel free to share that with your colleagues. My name's Mandeep Sandhu. I'm the head of the AML Proactive Supervision team, and I'm here today with my colleague Ross Gilson, who's the head of AML Policy. So just starting off then, we'll start with giving you a bit of an introduction and moving on to just talking about the financial sanctions regime. So sanctions, they're restrictive measures imposed by the government to achieve a specific foreign policy or national security objective. And in the UK, it's OFSI, known as the Office of Financial Sanctions Implementation, who are responsible for implementing sanctions. And it's worth noting that where sanctions are applied, they can be applied to individuals, entities, ships or planes, and they're usually referred to as designated persons. And we'll be referring to the term designated persons throughout this webinar. In the UK, there's a number of types of sanctions that can be imposed, and they include financial sanctions, which are administered by OFSI. And that might include asset freezes and restrictions on financial markets and services like investment bans. And it's worth noting that if a financial sanction takes the form of an asset freeze, it's generally prohibited for you to deal with funds or economic resources available either directly or indirectly for the benefit of a designated person, and also making funds and economic resources available either directly or indirectly for a designated person. And it's also prohibited to engage in actions that might directly or indirectly circumvent the financial sanctions regime. There's also trade sanctions that are applicable or may be applied, and that can include arms embargoes and other trade restrictions. And these are administered by the Department of International Trade. Immigration sanctions is another one that could be applied, and that might, for example, include barring the entry to a country, and they're administered by the Home Office. And finally, there's transport sanctions, and that might include controlling the movement of an aircraft or ships and preventing them from docking at UK airports or landing in UK airports. And that's administered by the Department for Transport. And you must ensure that if you carry out work for a designated person, that activity is permissible activity, and each set of sanctions has its own set of regulations which will let you know what you can and can't do in terms of the permissible activity. And you should know that any work you carry out for a designated person, in order to be paid for that work, you do need a license from OFSI. There's two types of licenses, and it's worth mentioning those in some brief detail. And they're known as either specific licenses or general licenses. And with a specific license, there's usually grounds under which that could be provided. And the most common one that you might be aware of is a license to obtain legal fees. And then a general license is usually issued if another licensing ground does not apply. And one of the examples you might be familiar with was the general license that was issued for Chelsea Football Club to enable them to wind down any existing work. Moving on now to the differences between the AML regime and the sanctions regime. And it's worth noting that with the AML regime, it applies to 2/3 of our law firms, whereas with sanctions, it's applicable to every single law firm, irrespective of whether you are in scope of AML or not. The other key distinction is that you look at 25% beneficial ownership with the AML regime, whereas the ownership and control test for sanctions is very wide, and it's really crucial that you understand who's sitting behind a company and who owns and controls it. So it's quite a wide test. With AML, there's a prescribed set of regulations telling you how you may deal with matters and what should be included in your policy, for example, and also how to carry out due diligence checks. Whereas the sanctions regime doesn't come with a prescribed set of rules. It's just informing you that you shouldn't break the regime or breach the regime. And I think one of the key things that's worth noting in terms of the sets of regulations is that you can't read across the regimes. Each regime is different, so you would really need to understand the regime in detail to understand it fully. The other key difference is that with AML, you can apply a risk-based approach, whereas with sanctions, it comes with a strict liability offence. And it's worth noting that with a risk-based approach, it means you identify your risk and you direct your resources at the highest risk clients and situations, but a certain amount of tolerance is there for failure. Whereas with strict liability, it means that irrespective of how good your controls are, if you commit a breach, enforcement action may still be taken. The other key difference between the two regimes is that the reporting requirements for AML are to submit a suspicious activity report, and that's submitted to the NCA, but there's actually wider reporting obligations with the sanctions regime, and they cover a number of areas. So you're under an obligation to report any breaches of the regime if you encounter a designated person, and you should also report if you're holding any frozen assets for a designated person. And one of the other key differences is with AML, it applies to client assets, and you should be carrying out those source of funds checks against assets that you're holding in your client account, but it doesn't apply to fees that you obtain for carrying out legal work. Whereas with the sanctions regime, you cannot obtain any payment without a license, and it applies to all money that you receive. Moving on next to how sanctions might affect your practice. So failing to screen would mean you are at risk of breaching the regime. So you need to make sure you screen all your clients and counterparties to ensure they're not a designated person. Because you don't want to be in a position where you might inadvertently provide a benefit to a designated person or receive a payment without a license, as to do so would be a breach of the regime. But overall, what we've found is if you have a good AML regime in place, it's likely that you would incorporate these risk factors in place, and those controls would maybe help you in terms of just mitigating the risk for a sanctions breach. In terms of how to screen, OFSI have a useful tool to help you screen your clients against, and there's a fuzzy search function incorporated within that for you to check your client names against that list to see if there is a name match. And there's more narrative on that in our guidance that we've published and also in the OFSI official guidance. But it's worth noting that you should check both the OFSI list and the list issued by the Foreign, Commonwealth and Development Office in terms of just checking your clients for any possible matches. The other way in which they may affect your firm is you might inadvertently find yourself in a situation where you've provided a benefit to a designated person. That's why it's really crucial that you carry out due diligence before you obtain any fees. And some of the examples in terms of how you might come across this is, for example, in conveyancing, you wouldn't be able to proceed with a conveyancing matter because you would be providing financial benefit to a designated person. So that's not considered a permissible activity. And it's also really important in your due diligence checks to make sure you are really looking behind who's sitting behind a company to make sure you're not inadvertently providing a benefit. With immigration, for example, you might be approached by a client who might be subject to a travel ban or travel restrictions. So you'd want to ensure you've checked them against the list. And similarly with litigation awards, for example, you'd want to make sure they're going to clients that aren't designated, and if they are, that you've got a license to carry on that activity where you've got an ongoing retainer. In terms of ownership and control, due diligence is quite a crucial step in terms of trying to comply with the regime. And we think some of the tools that you might have in place with your AML controls would be quite useful here. And I think just setting out that, really getting to the bottom of ownership and control and really understanding who your client is quite a vital step to understanding your exposure to sanctions. And obviously have issued some really useful guidance in terms of their appetite for ownership and control, which you can find on their website. And finally, in terms of your firm, you do need a license, as I've already mentioned, to obtain your fees, as you cannot receive payment into your client account without that. And so it's really important that your due diligence checks are done even before you receive payment on account to provide any services. Otherwise, you bear the risk of breaching the regime. And it's also worth bearing in mind that you may also bear a risk in terms of when you're carrying out work, that if a license isn't approved, that you may not then receive your fees. So it's something else that you need to bear in mind. Moving on now to some useful controls that might help your firm in terms of mitigating risks and what might be considered as a good control in terms of looking at how well your firm are complying with the regime. So we think carrying out a risk assessment is quite a useful control in terms of mitigating any risks. And some of the things we'd probably ask you to consider when you're carrying out this risk assessment is really looking at the types of services you're providing and whether that's likely to be impacted by the regime. So are you providing advice on trade or shipping? Do you deal with immigration type matters? Are you likely to come across a designated person or someone who's subject to a travel ban? And then also having a wider look at the geographical locations that your firm may provide advice to or where your clients are based. So are any of the countries that are subject to sanctions likely to, are you likely to attract clients from those countries? And then also what types of controls you have in place in terms of identifying and verifying your client, and also the controls and checks you do to look behind a company structure. I think having good policies and controls and procedures in place at a firm is a helpful tool. It could help your fee earners understand how what your firm's approach is and how you deal with designated persons and sanctions. And we also think it's useful having controls in place in your accounting systems to prevent the movement of funds where they may be frozen, and also to have the ability to identify if you are holding funds for a designated person. And what you'll note when you have a license is that there are terms attached to that license in terms of reporting and how often you report. So having good accounting controls in place is a really vital tool to identify if you've received money and where you may need to report that under the license. Client due diligence I've already touched upon, but it's worth considering what departments carry out due diligence in your firm. Do you do that widely across all the different services that you offer? Or does it just extend to AML services in scope? And you'd want to make sure that you've probably extended that out and incorporating a check against the OFSI list as part of your standard checks for due diligence, just to make sure the client isn't designated. You'd want to also check that your fee earners are familiar with the consolidated list, just so they know how to check that. And so providing some training in that respect would be quite a useful control for your firm. And just generally talking about training, I think training all relevant staff is quite an important measure, and that could be fee earners, anyone who's likely to come into contact with a client, and also account staff who are likely to have more of an eye on what's happening in terms of the money being received at the firm or sent out. One of the other good controls we think is having a reporting mechanism to escalate things to senior management. So where someone feels that they've come across a sanctions matter or a designated person, that there's a channel of escalation to senior management. So you can have that overarching oversight of what's happening at the firm. And then also carrying out an audit of your procedures just to make sure that you're doing what you can to mitigate any risks. And it's also really important to appropriately document the controls you have got in place, as it may be considered a mitigating factor in the event that you may fall foul of an offence. Moving on now to Ross.
Thanks. Thank you very much, Mandeep. I'm now going to go through some of the specific risks that may be posed to your firm and ways in which you can control them. So the first one is ownership and control, which Mandeep's already touched on. This is very different to the persons of significant control ultimate beneficial owner regime with AML, which rests on a 25% ownership threshold. With sanctions, the ownership threshold is 50%, or somebody who might be reasonably considered to be able to direct the entity's direction or to appoint or remove senior officers, which is a very, very broad test, as you'll understand. We have had a few instances which firms have described to us of where they've found ownership not in evidence, but control. So in one case, there was a designated person who was supposed to have divested himself of a UK entity, and then wanting to instruct a particular firm. The firm had a look through the entity's minutes of its board meetings and found that despite the designated person having divested himself of official ownership, the board meetings were still happening at his address. So ownership, no, but control, very much yes. There's also a situation, while this isn't a sanctions case, I think it's a relevant point, which I encountered at a firm a few years ago, where I was looking through the memoranda and articles of association which had been collected in due diligence and found that, unbeknownst to the fee earner who had gathered it all in, there was one line hidden in a company's memoranda and articles of association which gave complete control of appointing the key officers, such as chief executive and chief operating officer, to a trust situated in America. So again, ownership not necessarily, but control very much so. So do be aware of the contextual aspect of that. It may not all be in the black and white of who owns what in terms of who is able to direct an entity. Also, e-verification. Now, this is something where we find there are a couple of issues which repeatedly show up. And one is that, as Mandeep's mentioned, training is very important. And one aspect of this is that it's really important that fee earners understand what e-verifiers do and what they don't do. We have seen situations where people tend to over-rely on e-verifiers, and simply because something comes back with a big green tick on it and saying that they passed, that they assume that a matter is low risk, for example. That's not necessarily the case. These are helpful tools, but they're not necessarily determinative of the whole context. And this is particularly the case in relation to sanctions, where we've received reports from a couple of firms that e-verifiers aren't necessarily updating their sanctions detection as quickly as they might. And a couple of firms, as I say, have changed providers because of this. Now, sanctions do tend to come out of nowhere. They're not announced in advance, and generally the point is to cause maximum disruption. But you would expect to see updating happening fairly quickly after that. It may be that rather than rely on a third party, you just want to go straight to source and check Office's search function. Accepting money before due diligence is completed is generally a bad idea in any situation, but particularly so with sanctions because of this strict liability regime that we have. So be sure that only the people who need to have it have your firm's client account details. I think the days when people used to put their firm's client account number on their website are receding into the past. But be aware that there's nothing to stop anyone depositing money with your firm if they know where to send it. So make sure that people only know about it who need to know, and that they only know at the relevant time. And as I've mentioned, and this touches on e-verification a little as well, sanctions are ever changing. And every time something particularly egregious happens in Ukraine, some more people are sanctioned as a result. The list is always being added to. So as part of your ongoing monitoring, make sure that you're checking sanctions. Just because somebody wasn't sanctioned when they were taken on by your firm doesn't mean that they won't become a designated person in the future. It's also worth remembering that this is not just about Russia and Belarus. The sanctions regime touches all sorts of people, places, countries, entities across the world, and it's not possible to rely on what you might call a stereotyped idea of what a designated person might look like. So moving on then to how you can control this effectively. Now, if you have an existing AML regime, and generally speaking, I'd hope you do, it's quite helpful to be able to build sanctions into this. The two circles, if you like, of sanctions on the one hand and AML on the other do have quite a large overlap in a Venn diagram of the kind of risks posed and the kind of red flags that you would be looking out for. So do bear that in mind and think about how you can raise awareness within the firm of the risk of sanctions and see it as a separate risk, but build it into a regime so that people are aware of and are looking out for both. Now, having spoken a bit about the risks of e-verification, I want to talk briefly on its potential benefits. And one of these might be looking at overseas sanctions regimes. Because the OFSI search, while it is the most up-to-date, most frequently updated UK database, won't necessarily tell you about people who've been sanctioned by the United States or potentially by the EU. The G7 are tending to work in concert as far as the sanctions regime on Russia and Belarus is concerned, but there are some other regimes, for example, Cuba, which Europe and the UK don't sanction, but the United States do. And if you do business in that area, bearing in mind the reach, particularly of US sanctions, which claim jurisdiction over any transaction in US dollars, it may be something you want to look into. The next one is limiting work to experts within the firm. If you want to get into dealing with designated persons in any area under license, that's absolutely fine, but make sure that the people in your firm who are dealing with this work know what they're doing and that there's no chance that it could, for example, find its way into less experienced hands. Make sure that there's proper oversight of it. For example, if somebody comes into your firm wanting to deal with the litigation matter and then want to deal with conveyancing, that the proper oversight is retained. And you can do this by having senior management sign off on high risk matters and clients generally. If you subject people who are or may be subject to sanctions to the same enhanced due diligence measures that you would to, for example, a politically exposed persons, that can go a long way to making sure that you're protecting yourself. And then, because I don't think I can labour the point enough, don't accept payment until client due diligence has been in place. It is always difficult if you find yourself having to do that late on in a transaction, and just make sure that you're absolutely certain about the origins of money that's in scope of the AML regulations. It's helpful to do source of funds checks if they're necessary as early as possible to make sure that they are as expected and coming from a legitimate source. There are some subtleties to that, and we'll be addressing those in some future guidance with the Proceeds of Crime Act. Now, moving on to ongoing monitoring. I've already mentioned the importance of ongoing monitoring. This is a situation where, as I've said, you can't be certain that someone will remain unsanctioned for the entire time you're dealing with them. You might want to look at how you deal with ongoing monitoring. So some people, for example, will have an e-verification system where there are alerts set up which will send you a message if somebody becomes subject to sanctions or if they appear in the news for whatever reason. You might also want to slot into your existing systems a sanction search, perhaps at key points in a transaction. So one example would be conveyancing, where you have 3 clear stages: onboarding, exchange, and then completion. when the fee earner is going to be doing a number of checks anyway to make sure that things can move on to the next stage. So just build it into the checks they would do to make sure funds are in place and that the parties are happy and that the contractual position is settled, and just have them check whether anything has changed on the sanctions front. In terms of licenses, be aware that, as Mandeep has mentioned, they have limitations. Quite often, a common one is limitations as to the amount of money you can charge. Another one might be looking into how much time you're able to spend on a matter. They all tend to be limited in terms of how long the license is. General licenses, for example, come with an expiry date. The legal fees general license has just been renewed and will be up for renewal again in October. So make sure that you keep an eye on what these boundaries are and that you don't go beyond them. In terms of monitoring accounts and having controls in place, as I've said, it's very important not to receive money without having completed due diligence, not to receive money without having completed due diligence. I apologise. You can help consider and contain the risk once the money has got into your system by monitoring your client accounts carefully and making sure that things don't move from one part of the business to another in a way that's not permitted, for example, by a license. Again, make sure if you have an accounting system that there is a marker on file if the person is a designated person, setting out who needs to be consulted and what can and cannot be done with the assets. And again, in terms of monitoring licenses, limitations, movements of money, have some diary reminders in to make sure that you know when you're going to be needing to put in a license renewal. Bear in mind there may be quite a long lead time. So if you're looking to renew your license, make sure that you get it in as early as possible to minimize the amount of disruption. As I say, when you've got an ongoing matter, you need to be carrying out ongoing checks and at key points during it. If work has already started, then you do need to make sure that a license is in place if you want to receive fees. You don't want to be in a situation where you are finding yourself in breach of a license by receiving fees that either are above the terms of the license or are outside of the terms altogether. Okay, moving onwards, please. Now, what if things go wrong? Well, there are three particular points here: stop, contain, report. So if you find yourself in a situation where suddenly you've carried out some work and then it appears that the person you've been acting for was designated, just stop. Make sure that you don't do anything that might go outside of, that might breach the sanctions regime further, or that might cause you to be receiving funds from a sanctioned person or indeed transmitting them onwards. Just stop everything, take stock, gather the information. There is no issue in itself with telling the person involved why you are stopping work for them, because most designated persons will be aware or should be aware that they're subject to sanctions. The question, of course, of whether you need to submit a suspicious activity report under the Proceeds of Crime Act is a separate one, and that will need to be considered separately, and that will come with potential tipping off issues. But as far as sanctions is concerned, you're entitled to say, I'm sorry, Mr. X, we have found that you're subject to these sanctions and therefore we're stopping work. Next is contain it. Now, this is obviously easier if, as I've mentioned, you're keeping everything focused to a small number of expert staff. Make sure that there are no parts of the work which are being carried out in other departments that you weren't aware of, or if the client has instructed other people in the firm, make sure that everything is contained and that the breach can't be compounded. Then report it. Report it to OFSI. We also consider that this falls within reporting obligations to the SRA. OFSI in particular, in their enforcement guidance, say that they value early reporting, as do we. And the sooner you're able to give them a report of what has happened, why it happened, and what you've done about it, the better it's likely to make your position. In fact, moving on to the OFSI guidance generally, I would absolutely recommend that everybody takes the time to have a look through that. It gives a lot of context into what OFSI are going to look at as and when they encounter breaches. It gives you some good indications as to how to improve your position if the worst happens. And it also gives a good indication of what they consider to be indicative of ownership and control. It says very clearly that this is not a threshold test for ownership and control, but it gives a lot of context about the sort of things they'll be looking at. So have a look at that and see whether it's worth building it into your regime within the firm. Now, moving onwards to counterparties. As we've said, this is a strict liability regime, and you will need to manage the risk of breaches due to potentially the person on the other side or the entity on the other side being a designated person. Here we're following OFSI's guidance, which suggests that it is possible that they may take action where a breach has occurred with respect to a designated person who is a counterparty. So we would recommend that you do take measures to try to minimize and forestall that risk. So we do recommend that you undertake checks into the sanctioned status of counterparties. However, this should be proportionate. You wouldn't necessarily need to go into the same detail as you would for checks on your own clients. One way to do this, which was suggested to us and we think is a really good idea in a previous webinar, is just to integrate it into your conflict checks, which you would do anyway. So when your fee earners are onboarding and checking the firm's own systems to see whether you've acted for the counterparty in the past, just make sure that you check whether or not they're subject to sanctions as well. And again, OFSI's website, including their search function, seems to be the most expeditious way of doing that. Okay, now that takes us on to the final slide. We have time for questions now, and we have had a few questions submitted ahead of time. If we don't get through to answering all of them, we will look through them and see whether there are any things we can cover in our future webinars and communications, for example, in our question and answers. We do want to hear what you thought of this webinar and today's events, whether it was useful, what the sort of content you'd like to see covered in future. If you could click on the evaluation link below this video screen and let us know what you think. It takes a couple of minutes to complete and will really help us to improve. We'll email, okay, and we also have an email address there if anything occurs to you, aml@sra.org.uk. If you have any queries, we will be happy to look into them and either answer them ourselves or provide further guidance as to where you might be able to get the answers. We've published our own guidance there. And again, just if you go to that link, the OFSI sanctions guidance, that will give you detailed guidance on sanctions in general, on particular regimes, and on the enforcement guidance that Mandeep and I have both referred to. So with that in mind, we shall move on to questions.
Thanks, Ross. I'll start off with the first one. So I'm a high street conveyancer. All of my clients are UK nationals from the local area. isn't it overkill to do all these checks against my clients?
It might seem like overkill, but we don't believe it is. One statistic which I'm fond of quoting at people is that I think as of last week, when I last checked, there were 66 people on the sanctions register who were British nationals or dual nationals. So it's not possible to have a stereotyped idea of who might be subject to sanctions. Also, bear in mind that we're looking here into ownership and control. And as I've said, that can be quite a nebulous, multi-layered thing. You're very unlikely, perhaps, to get somebody who is the owner of a large sanctioned gas company, say, coming into your high street practice, but you might deal with an entity which is owned by another entity, which is owned by another entity, which somehow has links to this person or this company. The layering makes it difficult to anticipate where these people are, where the assets are coming from. It's a similar concept to AML, which has many of the same risks. So I think the answer is that since you could never be absolutely sure until you've conducted due diligence, hopefully properly, that it is best practice to apply the same level of scrutiny to everybody. This may seem, as I say, like overkill, but given the risks involved and the easy availability of doing a basic sanctions check, it's entirely proportionate to just do that and make sure that you're minimizing the chance of dealing with any sanctioned assets or dealing improperly with a designated person. Okay, now we've got another one coming through. Yes, this is about our data collection exercise. So I've received a request for information about sanctions from the SRA. Can you tell me a bit more about the purpose of this and what it will be used for? I think that's one for you, Mandeep, as your team is overseeing it.
Sure. So just for background, the reason for the exercise is for the SRA to understand the sanctions risks within the legal sector. We already had some sanctions questions in an AML data collection exercise that we carried out last year. So these emails for this information request is going out to those firms that are out of scope of AML, just so we can understand the sanctions risk in that part of our regulated population. So the assessment of risk will actually feed into our wider proactive work that we are due to carry out on sanctions, and there may be some engagement with firms in due course based on their risk exposure. But one of the key things I did want to just set out is some of the questions are around controls. So just using an example where we're asking if you have a written policy on sanctions in place. If the answer is no, that's absolutely fine. Be as honest as possible. There won't be any referrals for investigation off the back of that answer. But it is a mandatory exercise, so you will need to get your responses in, and a failure to do so may lead to an investigation. But we're hoping that that probably addresses some of the concerns in terms of why we're going out for this exercise. Next question. Can I pass on the cost of screening to my clients in the same way that I can for AML checks?
Absolutely. The same considerations would apply as for AML, which are that as long as you're upfront with your client about the charge and the reasons for it, and that it's done at a fair and proportionate rate, then absolutely you can pass on the cost to the client. I think the other thing just to bear in mind to this, and it's not peculiar to sanctions or to AML, but just a general point of good practice, is to make sure that you're clear when it comes to billing as to whether it's a disbursement or a profit cost, because some firms have in the past got into trouble with HMRC over VAT when I think it was telegraphic transfer fees have been put in the wrong column and charged wrongly. But absolutely. Do be upfront with your clients, but as long as that's done, you can charge. Okay. There's one here for the sanctions questionnaire for you, Mandeep. So the sanctions questionnaire doesn't seem to accommodate firms who do not deal in transactional funds. So the firm has to answer no to source of funds checks. Will this attract attention when it's not applicable?
Again, this is a collection exercise just to understand exposure, but also to understand the types of controls your firm do have. So there's a couple of options to that question. You can either say you do source of funds checks for transactional matters, that you do it for legal fees, or you don't do it at all. And we have at the bottom of the questionnaire put in a comments box if you feel like you want to put that commentary in the bottom of the questionnaire, please feel free to do so. But as I said, this is a data collection exercise just to make sure you are carrying out the right checks. But what I will just point out in terms of useful controls is, providing you're satisfied and you've done the right due diligence checks, you want the right controls in place at your firm to make sure that the money you're accepting isn't from a designated person. So that's why that question is there. But no, it wouldn't attract any specific attention on that question. Great. So another question here we've got, so when do we, if ever, have to sanctions check another solicitor's client?
I think this goes into the section on counterparties I discussed, and again, we suggest that you do it. We suggest that you do it as broadly and widely as possible, because there is always a risk that if you're going to be, if you're in a litigation matter, for example, and the parties agree to settle, and your party is going to be paying the other side, that there's a risk of a sanctions breach. As I say, though, it's pretty quick and easy to do. So just build it into your existing processes around conflict checking, and then you can satisfy yourself that it's being done well. Hopefully you're conflict checking all of the counterparties, so that if you do that, you can make sure you've got 100% coverage and hopefully keeping out as much risk as possible. Okay, I can see one's come in. How often are firms recommended to check in ongoing retainers that a client has not been subject to sanctions? Do you want to take that one, Mandy?
Sure, thanks, Ross. So ongoing monitoring is a really crucial step in terms of complying with the sanctions regime. So just by way of example, last year when the Russia sanctions were put into place, sometimes hundreds of individuals were being designated overnight. So keeping on top of that was quite a crucial step, as you may have already had a client that you were working for that has then become designated. But there are a couple of good controls that you can put in place at your firm to help you deal with ongoing monitoring. So OFSI do send out alerts every time they designate new individuals, and I'd really encourage all law firms to sign up to those alerts. So as soon as a new designation has been placed, OFSI send a alert out, and if you sign up to those alerts, I think the best thing would be to then check that individual against your client list to make sure they're not an active client at your firm, and if they are, then start putting in the relevant controls in place to make sure money isn't moved and that you have a license to obtain fees. But ongoing monitoring checks are really crucial. The list changes quite often, and it's really important to make sure you keep on top of those changes depending on the length of your retainer.
Okay. Oh, and we've got several on the same topic, it seems, asking about which firms are being asked to do the sanctions return at this time. I think this one's quite pertinent because the sanctions exercise went out yesterday. Do you want to do that one as well, Mandy?
Sure. So every firm who is not in scope of the anti-money laundering regulations has been sent the questionnaire. You can find out more on our website in terms of whether you are in scope or not. So that went out to all law firms who aren't in scope, and they've been asked to complete that return, as well as those who, in our last AML data collection exercise, told us they are no longer doing AML work. They would have received a return as well.
Absolutely. And then I think it's also worth pointing out that the reason this isn't going out to firms in scope of the AML regulations because those were subject to last year's information collection exercise, which had a few questions about sanctions as well. Okay. Right. Okay, one's come in. If a UK lawyer is acting for the counterpart, can I rely on them to tell me if the counterparty is subject to a sanction, or am I inspected to investigate the ownership and control of the counterparty? I think this has come up in a few different areas about, for example, in conveyancing, asking the other side to confirm that they've abided by all of the AML regulations, and I've started to see it coming up in sanctions as well. I think the question to ask yourself is, if everything did go wrong and you found that you'd breached the sanctions regime, there's not likely to be a huge amount of comeback that you're able to do if the other side has confirmed that, or simply ignored the question of whether or not they have done the AML checks or the sanctions checks. And we wouldn't necessarily expect you to investigate ownership and control in the same way as you would your own clients. As I said, it should be proportionate. But it's also something where you would want to make sure that that you were doing, at the very least, a brief check on Ofsey's register. Now, that said, if you found yourself in a very dealing with a counterparty who was particularly risky, for example, if you knew from reports you'd seen in the news that they have connections to several sanctioned individuals and entities, or that they were, say, a Russian or Iranian state entity or had connections with them, you would probably want to dig a little further just to satisfy yourself that you were eliminating as much risk as possible. But in general, we'd say take a proportionate view. It's also worth noting that one of the other differences between the regime around sanctions and that around MLRs is that there's no scope for reliance. As we said before, strict liability. So that really is what poses the majority of risks here, the fact that there's no scope for reliance, no scope for a risk-based approach. We suggest that you take a proportionate but risk-averse view on this.
I think I might just add that it is a strict liability offence. There is no allowance for reliance under the sanctions regime. And I think you also need to ask yourself how comfortable you are with the other firm's controls, and that you're confident that they've come across the relevant checks, and that they would highlight that with your firm. Right, we've had another question, and that is from Ross, and that question is: what is the situation regarding a client or sponsor in an immigration matter if they become subject to sanctions after the work has already started? Do you want me to take this, Ross?
I think I can guess what you're going to say, but yes, please.
I would say you need to make sure if there's any payment you're holding in the client account that you make sure that's not moved anywhere. You'd need to get in touch with the Home Office in terms of you'd need to consider the application that you're making and whether that application is against what the ban is. So if there's a travel ban or a ban on leave to remain, you'd want to make sure you understand the details behind that. So the Home Office would be the relevant department for you to get in touch with. But I think in terms of the controls at your firm, you'd need to make sure you're no longer accepting payment from your client or the sponsor without a license to do so. So you need to make sure that discussion's had with the client just to mitigate the risks for your firm. And I think one of the other things that we haven't touched on in the webinar, but it's worth noting that if you've got outstanding bills that haven't been paid, you aren't allowed to receive payment of those bills without a license, and you also can't write off those bills without a license either. So there's some of the things that you really do need to bear in mind in terms of someone that's become subject to sanctions after you started acting for them. You can carry out legal work for an individual without receiving payment, but obviously you bear the risk that the license might not be approved. But the key thing to note is that you can't have that payment without the license. And the other crucial step is to make sure that the work that you are carrying out for that individual is actually permissible activity.
Absolutely. I think it's also worth saying that given how fast moving many of these things are, the minute you get an inkling that a client is or might be sanctioned, get that application in for a license, because there is quite often a lead time. Okay. Right. Now, one's come in, and I think this is the last one we have time for. I've had an AML result which has come back as a pass, but says the e-verifier says that its checks indicate that a name match has been found on the PEP or sanctions list. However, the individual has since been cleared by their system. What other checks do I need to do? Shall I take this one?
Sure.
One of the things that has that we've had back from several e-verifiers about is that quite often there are false positives where somebody shares a name with a politically exposed person or somebody who's been sanctioned. The situation here seems to be that they've found a name match, but that the name match has been found not to be valid. It depends on what your particular system does, and it might be something to check with them what the actual meaning is if it's been cleared after initially finding a match. If it's a situation where the system has checked it, you might want to run them through OFSI just to make sure, and maybe in terms of you might want to do a bit of open source searching just to double check. But on the face of it, it sounds like the system has investigated and found that it's not actually a match. But I think one thing that slightly bothers me about this is that the system doesn't seem to be clear about whether it's a PEP or a PEP match or a sanctions match. And the two are very different. They overlap in some areas. For example, Vladimir Putin is both a PEP and somebody who's subject to sanctions. But they are two different regimes. And one key difference is that while there is a list of everybody who is subject to sanctions, there is no list of PEPs, nor could there ever be. So I think that's something to investigate with your provider as to what exactly it's checking for and what exactly it means when it says there was a match but there no longer is. Regardless, I would say it's worth taking the time just to run the name through OFSI's search just to be absolutely sure.
I think that's right. I think carrying out independent checks outside of the e-verification system that you're using is a good tool. There's other things that you can look at, for example, whether the date of birth matches to rule out whether they are the same individual. So carrying out those checks. And I'd also say it's quite crucial to document your decision making. So what inquiries you made and whether that led you to determine whether that was the designated person or not.
Okay. Right, well, that wraps everything up, I think. Thank you very much for listening. And I think just again to say that we would value your feedback. If you care to give it, there should be a link there for you to give it. aml@sra.org.uk if you have any further queries for us. And as I say, we will look at all of the questions that we weren't able to get to and see whether we can answer them through our other communications.